A project manager is dismissed after raising concerns about workload. The employer says it was a performance issue. The employee says it was retaliation. Same situation, two completely different narratives. And in employment law, the side that builds the stronger case is usually the one that understands one key thing early on. Evidence wins cases, not assumptions, not emotions. Evidence. So how do you actually build a strong employment law case? Let's break it down. First, timing matters more than most people realize. Many employees wait too long before taking action. They hope things will improve. They try to push through it. They avoid conflict. But the earlier you start documenting what is happening, the stronger your position becomes. We recently advised an employee who waited months before raising a grievance about unfair treatment. By the time legal advice was sought, key emails and messages had already been deleted by the employer's system. That made the case harder to piece together. Second, documentation is everything. If something happens at work that feels wrong, write it down. Dates, times, who was involved, what was said, what followed afterwards. Keep emails, save messages, keep copies of meeting invitations and notes. Because in a dispute, your memory is not enough on its own. Third, consistency is powerful. If your account changes over time, it becomes harder to rely on. But if your story is consistent from the beginning, supported by documents and records, it becomes much more credible. Now let's talk about something many people overlook. Context. A strong case is not just about one single incident. It is often about a pattern. For example, repeated criticism after raising concerns, sudden performance issues after years of good reviews, or exclusion from meetings following a complaint. Individually, these moments might seem small, but together they can tell a very different story. Fourth, understand what legal claim you might actually have. This is crucial. Some cases are about unfair dismissal, others involve discrimination. Others relate to unpaid wages, breach of contract or whistleblowing. Each type of claim requires different evidence. We often see employees focusing on what feels unfair emotionally, without linking it to the legal framework. That can weaken a case unnecessarily. Fifth, follow internal processes carefully. It might feel frustrating, but raising grievances, attending meetings and following procedures can actually strengthen your case later. It shows you tried to resolve matters properly. And tribunals take that into account. Now let's talk about witnesses. Where possible, identify anyone who may have seen or heard relevant events. Even if they are not willing to formally support you, knowing who was present can be useful later. And finally, get advice early. Not because every situation leads to a claim, but because early advice can stop mistakes that are difficult to fix later. We see this all the time. Employees resign too quickly. They miss deadlines. They send emotional emails that are later used against them. Or they fail to realize they may have stronger legal rights than they think. So what is the takeaway? A strong employment law case is not built overnight. It is built step by step. Through careful documentation, clear thinking and understanding what actually matters legally. At Blackstone Solicitors, based in England, we help employees build and assess employment law claims, including unfair dismissal, discrimination, and workplace disputes. Because in employment law, preparation is not just helpful, it is everything.